Thank you all for joining us today on RAIN Africa's hopefully last workshop for this year. My name is Lord Amma, one of the founders of RAIN Africa, and I have the great pleasure to open up the event today of the Responsible AI Africa Network Africa, popularly known as RAIN Africa. RAIN Africa was founded through a partnership between the Kwame Nkrumah University of Science and Technology in Ghana and the Institute of Ethics in Artificial Intelligence, also known as the IEAI at the Technical University of Munich. We currently have about 10 country representatives across Africa. And the aim is to build a network of scholars working on the responsible development of and use of artificial intelligence in Africa. So today we are going to present on the responsible AI and data protection. That said, I would like to welcome now the moderator of the event, Dr. Corrigan, another co-founder of RAIN Africa. Dr. Corrigan is the executive director of the Institute for Ethics in Artificial Intelligence at the Technical University of Munich. That is the IEAI. At the IEAI, she's responsible for developing strategic partnership for the Institute and to enhance their academic networks. She holds a PhD in Public and International Affairs from the University of Pittsburgh. Her research interests include good governance, sustainable development, and corporate social responsibility, particularly in developing country setting. She has over 10 years of experience in designing and implementing research and data collection, developing and managing research projects, and coordinating funding proposals. She has also conducted field-based research in Southern Africa with focus on CSR, natural resource management, and community development. Dr. Corrigan has published several articles in academic journals and has worked as a consultant for local and international NGOs through research group of sustainable impact, example, the RGSI, producing data collection and evaluating system for organizations, conducting statistical data analysis, and generating policy relevance research and reports. Caitlin, I would like to hand over to you to welcome our panelists for today.
Thank you so much, Loud, for that introduction. Today, RAIN Africa brings a new edition of our workshop series, as Loud mentioned, and the final one for this year on the theme of responsible AI and data protection. Today, we will have 3 experts, panelists, share their insights on the regulatory landscape and measures across Africa in the context of AI in particular. So I'm going to start by introducing them one by one, and after each introduction, I'm going to allow each of our panelists to make some introductions on the topic from their perspective. We'll then have plenty of time for an open discussion period where I hope to hear from all of you audience members using the chat function, or you can use the raise your hand function. But until that time, I ask that all the audience members keep their microphones and cameras off during the event. So first, we're going to hear from Bev Townsend. Bev is a postdoctoral researcher at York Law School at the University of York in the UK. She holds graduate degrees in law and a PhD. Her expertise is in integrating law and ethics into safe and resilient autonomous systems, such as robots, among others. Her research has focused on privacy, data protection, law, data sharing, and international data transfers, ethics, human rights, and biotechnologies, AI, and regulation and governance. She's an honorary research fellow at the UK ZED. Bev, I give the floor over to you to give us your perspective on today's topic.
Thank you very much. So I'll just share my screen, if I may. Can everybody see that? Okay, great. Okay, so thank you very much for that introduction. My name is Bev Townsend, and I am a researcher at the York Law School at the University of York in England, and my work has been at the intersection of law and ethics and of technology, specifically looking at resilient autonomous systems and robotics in the Trustworthy Autonomous Systems Resilience node. but I'm also an honorary research fellow at the University of KwaZulu-Natal in Durban, South Africa, where I lead the DSI Africa Law subgroup on AI in Africa. So just to describe some of the work that we've been involved with at UKZN, and that has really been a mapping process where we map artificial intelligence and digital health legislation and regulatory landscape across 12 African countries. And this is work that is still in progress. It involves a team of researchers at the University of KwaZulu-Natal and across 12 African jurisdictions. And what we seek to do essentially is to map the legislative and regulatory position across these 12 African countries, and so to establish a point of departure and a basis for future policy development and analysis across the African continent. So the 12 African countries that we've been looking at is firstly Botswana, Cameroon, Gambia, Ghana, Kenya, Malawi, Nigeria, Rwanda, South Africa, Tanzania, Uganda, and Zimbabwe. Okay, so just a second. So as we may know, is much recent and ongoing development has been conducted around the regulation and governance of AI in the global north, most notably the IEAI Act, the US Algorithmic Accountability Act, the US introduction of the Blueprint for the AI Bill of Rights, and the recent Canadian Artificial Intelligence and Data Act, to name just a few. I mean, there are, of course, many others, but a lot less attention has been directed towards, and in fact, very little is known about the AI regulatory position emanating from the global south, although there have been some recent developments, most notably the Brazilian AI bill in 2021. So what we sought to do is really to question the position of AI regulation in Africa. And we asked quite simply, what has been done? And is it fair to state that there's very little or nothing being done on the African continent? So to answer this question, what we did is we undertook a scoping exercise, which has not yet been completed, and we hope to publish our results in early next year, but where we considered the strategy documents, legislation, policy, and regulation across Africa. It was not our intention to capture the various and numerous ethical instruments out there or any additional governance measures that might find application within a particular country, nor did we address any non-legal issues such as internet penetration, digital literacy, skills development across the 12 African countries, or governance frameworks that might impact or address availability and affordability of ICT services. But what we did rather was we anticipated that there would be no specific AI law in Africa. But as we all know, the consequences of AI adoption are both far-reaching, and they touch many areas of ethics, law, and regulation, including issues of social justice, discrimination, explainability, and the like. So what we did was we narrowed our focus considerably, and we addressed only certain key issues that inform AI adoption. And we looked at, firstly, AI, digital and technology strategies and policies, if there were any within these 12 countries, data protection, digital health, consumer protection, constitutional protection, and intellectual property. And some of our preliminary findings, and I just note with caution, they are in fact only preliminary findings, so just take that as I position it. And what we did find was that work had in fact been done on the African continent. At a regional level, we perhaps all know about the African Union Digital Transformation Strategy, the Malabo Convention, which is really the AI Data Protection and Cybersecurity Convention, and then the more recent AU Digital Policy Framework, which also looks at cross-border data flows and various other elements of data protection and data policy. And then Other instruments on a sub-regional level were also found, but what we found at the end of the day was that coordinated efforts at a sub-regional and a continental level may be of assistance to capitalize on strategies across African countries and in fact beyond them. Further preliminary findings was that although there was no specific AI legislation existing in any one of the 12 countries, it's perhaps unfair to say that nothing, in fact, has been done. Encouragingly, advancements in AI-related regulatory and policy initiatives across the African landscape have, in fact, been initiated. However, they are diverse and they are in some instances fragmented progress. But this really just speaks to the idea that significant work is yet to be done. All targeted countries are therefore really at an early stage in the AI regulatory journey. And notwithstanding recent policy developments, African regulation and policy, much like elsewhere in the world, in fact, where found, are either of general application to all technology types or adapted from other older digital technologies and not written specifically with AI in mind. However, certain aspects of the development and deployment of AI are informed by either issue-specific, such as healthcare laws, or sector-specific legislation, such as data protection laws. And all countries, in fact, had at least one digital fourth industrial revolution technology or technical strategy, policy, or roadmap in place, which included efforts on the digital economy, cybersecurity, and aspects of smart technology. And also encouragingly, certain sectors that inform AI development, such as data protection, had seen recent development in recent years. And in fact, in our scoping exercise, we demonstrate that widespread adoption of data protection frameworks were noted, with specific law in 9 out of the 12 targeted jurisdictions. The remaining 3 had data protection in place in some form or another, which I think is a very significant finding, in fact. Also, all the 12 countries had adopted a digital health or an e-health strategy. This refers to the use of digital technologies, including AI, but not necessarily so, as a means to address chronic challenges in the provision of quality, accessible, and affordable healthcare. Legislative frameworks, of course, which is to be expected for healthcare, existed in all 12 of the jurisdictions. And these comprise various national health acts and statutes and regulations governing the practice of health professionals, health research, and the manufacture and sale of medical devices. However, what is lacking is any guidance in these areas addressing the actual impact of AI. And this is a critical shortcoming, as clear laws, regulations, and governance frameworks are necessary to promote trust in and the adoption of new technologies. All 12 countries had IP laws in place, and only some of them had consumer protection laws, including e-consumer protection, in place. So really, that's just our preliminary findings in a nutshell, but discussion topics around some of the regulatory concerns or interests or issues is really the use of regulatory models, and how do we go about and how do we account for cultural diversity and make AI regulation and ethics and philosophy more appropriate and relevant to a local context or area. And we really then also question whether the leading exemplar of the IEAI Act is appropriate for Africa at all, and whether it should be the gold standard, much like the GDPR has sort of become. Because in Africa, we may wish to do things differently and more from a regional perspective. In fact, even the UK is adopting a very different approach to the way in which AI will be regulated. So Africa has different perspectives, it has different narratives, it has different requirements. So what we essentially do is we call for a broader, inclusive, and participatory discourse on AI regulation adoption more generally, and in Africa in particular. And that is the end of my talk.
Thank you so much, Bev. I was making notes on a lot of questions that I have, and I'm sure our audience does too. But I think we'll first hear from our other panelists, and then we'll have a lot of time for discussion. So next, we're going to hear from Arthur Gwagwa. He is a research scholar based in Utrecht University Ethics Institute. His research focuses on the geopolitical implications and the ethics of socially disruptive technologies, AI, big data, and their regulation. Arthur sits on various international boards, including the U.S. Open Technology Fund Advisory Board, the Stanford University Journal of Online Safety and Trust Board, and the United Nations Global Pulse expert on AI and big data. Arthur, the floor is yours.
Hello, good afternoon. Thank you, Kathleen, for their kind introductions. So I'm not going to repeat what Bev has already covered, because what Bev has done is to give us a picture of what's on the ground. But I like what she said at the end, that there's no guidance on developing critical AI, and whether Africa should copy and paste what the European Union is doing, hook, line, and sinker, or whether it should chart its own course. So I think this is what I'm going to talk about. Instead of focusing on the descriptive, I'm going to talk about the normative. I think what should be. So I'm going to talk from my own experience of having been involved in as part of the UN Global Pulse, working with the government of Ghana on the data protection framework, but also the fourth industrial revolution strategy in Uganda. And also prior to that, I was at Strathmore University, and then prior to that, I was at the University of Cape Town. So I think some of you might be familiar with a couple of papers that I wrote. The first one was on AI policy dimensions in Africa, and the second one was focusing on agriculture. So I'm going to be drawing some examples from agriculture mainly. So as Bev covered, I think Bev spoke about data protection legislation in Africa. But I think what is also not clear is the extent to which Africa is taking seriously their issue of non-personal data, because most of their data protection legislation that I've gone through in a number of African countries, I think about 26, mostly focuses on personal data protection instead of non-personal data. So we have got genomics data, we've got biodiversity data, bioprospecting data, data about our heritage and our culture. Let me just give you an example. Recently, there was a movie, I think in Canada, which was trying to reincarnate one of the African heroines. So this, I think what I say, cultural knowledge about Africa, indigenous knowledge, is also very important, to be protected. Because when you come to the industrial north, the European Union is actually busy in the process of passing the Digital Data Act that protects non-personal data. And it is passing a number of measures and regulations to ensure that industrial data is going to be shared with other partners subject to some safeguards. So this is where I think Africa is also lagging behind about our natural environment, our own inventions, our own stories, that they actually need to be captured in the regulatory measures that are being taken. So in terms of responsible AI, what exactly is responsible AI? So there are two issues that are normally emphasized in international discourse and also in bioethics. That's beneficence and non-malfeasance. So beneficence means that AI should promote social good. Non-malfeasance meaning that it should do no harm. These are very general principles that do not say much, that need to be contextualized. So the problem that we have is that artificial intelligence has changed the notion of technology. Whereas 20 years ago, I would go to a shop and buy a refrigerator and know that I own that refrigerator. The seller or the vendor has got nothing to do with it. But now we've got a situation where these gadgets are fitted with sensors that keep on sending data to the vendor or the shop owner. So it has changed the how we perceive technology, the anthropology of technology, in the sense that the owner has got a continued interest in the product that you buy, because it's the business models that we have actually are based on that continuous harvesting of data. So if you think maybe, well, the fridge is not a good example, let's talk of maybe tractors that are fitted with sensors, or aeroplane engines, Rolls-Royce engines that are fitted with sensors to continue collecting information, say, for the next 30 years. So why am I bringing this? So the deployment, the design deployment and the use of responsible AI should actually start with a why. But what is the problem? Then we start designing AI products or data collection modalities that suit the specified purpose with some adjustments, of course. Let's take a few examples in agriculture. So in the paper that we wrote with my co-authors, which is called the Roadmap for Responsible Artificial Intelligence and Development in Africa, we asked some questions. We asked big questions to say, well, if we are deploying AI-based algorithm, how are they being used and what should they be used for? Or let's take it, for example, food production. If TensorFlow library, that is the data flow and the TensorFlow programming is being used, applied to take some data sets from, say, cassava leaves, we need to ask some questions. Are there any context or any other domains that TensorFlow library applications could be used for? And then we go to geospatial data. We need to, we shouldn't just be excited that maybe Zimbabwe is sending a satellite, first satellite. We need to ask some questions. Who is owning that satellite? Who is going to be owning the data that the satellite is going to be harvesting? So let me just give you some examples. I've given one example of Google's AI open source library, TensorFlow, which monitors disease from cassava leaves in Tanzania, Uganda, and Kenya. Because the AI capability surpasses that of humans. So that is actually responsible deployment of, because the human is in the loop. It's human-centered. We are asking the question, can AI do this task than the humans can do? And then we've got the GIZ, the government of Germany, that is actually working with some stakeholders on the ground right now to take some multimodal data from speeches to images from farmers in order for them to improve and diversify the training of speech and image classification algorithms. That's responsible AI, because they are to ask the question to say, well, what are some of the challenges? What are some of the struggles that the farmers in sub-Saharan Africa are facing? And then GIZ came in and then is starting to help them collect data. But what is irresponsible is for a government that just wakes up one day and start collecting your biometric data without even telling you why that data is being collected, because that is actually the focus in Africa at the moment. That data is collected without explanation as to why that data is being collected. That gives rise to a number of challenges, the surveillance capitalism, but also colonialism in the digital age. Another good example in Africa is aerobotics and Hello Tractor, but we also have IBM Watson. Aerobotics collect data sets to improve agricultural outputs. So when you look at the examples that I'm giving, these are domain specific. So when we were crafting the Ghana strategy, one of the questions that we were asking was, should regulation be general or should it be domain specific? So for me, I think responsible AI start with a why. And secondly, it should be based on solutionism. Sorry, it's a very hard word to explain. So we should have the human and the social back into the loop. Because many experiential aspects of human life are lost if we restrict ourselves to machine or AI compatible approaches to science. So machine learning is not AI. AI is broader than machine learning. AI includes data, it includes norms, it includes systems, it includes people, it includes the questions that we ask in our society. So if my grandmother or my mother can't ask that question, it means that that AI is not beneficial for our society. So one of my colleagues, Dr. Saestre, suggests that AI programs, in order for them to be responsible, they should be tied to sustainable development goals. And because sustainable development goals cover 3 broad areas: economic, social, environment, but they are also accepted by governments, businesses, and civil society. So the Ghana strategy that I was talking about is actually heavy on emphasizing the UN sustainable goals, because it gives us a standard benchmark by which we can judge whether AI is addressing the real needs of Africa today. Let me talk about bad examples, because right now, whilst the African governments are leveraging on data, focusing on data, one of the things is machine learning, that is the algorithms, are being driven by global technology companies. So the regulation of machine learning algorithms is actually following the sandbox approach. So when Bev was talking about, I think, the lean regulation on the ground, it's because we actually don't know as Africans how to govern machine learning algorithms, because machine learning algorithms do not belong to us. They belong to Silicon Valley, they belong to Shenzhen. But what Africa can do, and where we are good at, is we've got our data sets, not just personal data, but we need non-personal data relating to indigenous knowledge, biodiversity data that I was talking about. But we've got the people as well, our youthful population. We've got the resources. This is where we need to be focusing on. So let me talk about the big platforms that have extended their infrastructure of domination into Africa. Microsoft Azure Cloud, the Amazon Cloud Services, that are supporting Airbnb, Uber-based businesses in Africa. So sometimes they do a good job, but they also do a bad job. Let's take a bad example, what are called large language models that have been causing a lot of controversy lately. So large language models cause a lot of carbon footprints, and also secondly, they are excluding African languages because they are called low resources language. And then another example is about chatbots. The fintech in Africa right now, they are actually buying what is called software as a service from abroad, and then they call it what? Artificial intelligence. And in terms of regulation, or what we call norms, the norms are coming sometimes from the Budapest Convention, which means that some of the norms that we are following are European, apart from the GDPR. So what do I mean by chatbots? That maybe chatbots are bad, or software as a service are bad, because we are applying what is called techno-solutionism, which is a focus on technology without focusing on what is called the socio-technical ecosystem. So the socio-technical ecosystem is the systems, the interdisciplinary intricacies, the interconnectivity, the interdependencies, and all the elements that actually work chatbots, that make chatbots work, that enable chatbots work to work properly. So we've got chatbots. You phone a bank today in Uganda or in Kenya, and then the chatbot is leading you from pillar to post without giving you an answer, because we are simply deploying the technical functions of artificial intelligence without questioning the why, without questioning the socio-technical system, without knowing what we call the pain points, that if this chatbot were to fail, what are the default points, without really knowing exactly why we are buying those products and imposing them on the African populations. Then another good example. So in building socio-technical systems or artificial intelligence, we shouldn't just be focusing on machine learning, because machine learning is simply a small but very powerful and significant part of artificial intelligence. But it is rent-seeking. But artificial intelligence is actually based on socio-technical systems. Let's take, for example, Samasos in Kenya, where local people are involved and consultant in building data capacity. This is what we call socio-technical systems that actually that do not cause epistemic injustices, but that rely on local labor, on local knowledge in order to build AI ecosystems that are beneficial. Then the last example is biometric systems for public service. We know African governments are deploying biometric systems which are being deployed in the absence of regulatory frameworks. My colleague Carissa Velis at Oxford University says the very act of turning what was not data into data is a form of surveillance. So it is bringing about digital colonialism again and invasive surveillance, because we are not exactly being told why our biometric data is being harvested. So collecting personal data might be convenient, but it brings about a lot of serious privacy implications. So we need to balance personal and non-personal data. And going forward, when it comes to data flows across the borders, let me bring in my philosopher hat back as I close, that Africa shouldn't be against interference, cross-border data flows, but it should be against what is called domination. And what is domination? Domination are infrastructures that put African populations in an asymmetrical position. Let's talk, for example, the biometric system that China is building. When the local populations are not being asked, it causes epistemic injustices. It challenges our values. In other words, our data is going to be used without knowing how we are going to benefit at the end of the day. So we need to ask the why, the big question, the purpose, why that data is being collected, and have people been consulted, and what have the people said? And after we have done that, it means that I think our choices are being respected. Our choices are not being restricted. And that is actually what is called non-dominating application of artificial intelligence. With that, I say thank you.
Thank you so much, Arthur. Really, a lot more points I want to get us time to cover after our last presentation. But next, finally, I'm very pleased to welcome Tiki Akute. She is an ICT telecom lawyer, a privacy data protection consultant, a senior partner at a law firm based in Accra, Ghana. She is also the founder and executive director of the African Digital Rights Hub, LBG, a member of the UN Global Pulse Privacy Advisory Group, and a non-resident fellow of the Center for Global Development. Previously, Tiki has worked for the government of Ghana in the development of several key legislations for the ITC sector, including the Data Protection Act of 2012, the Electronic Communications Act of 2008, and the Electronic Transactions Act of 2012. She was also the first executive director of the Data Protection Commission of Ghana. She holds an LLM in Information Technology and Telecommunications Law from the University of Strathclyde in Glasgow, and a Bachelor's of Arts in Law and Political Science from the University of Ghana. Welcome, Tiki. Oh, microphone.
Yeah, thank you. Thank you very much, Caitlin, and thank you to all the organizers of this workshop for bringing me on board. So this is indeed a very interesting subject area from what has been looked at by Arthur and Bev. I was asked to talk about responsible AI and data protection, and so I will be looking at it from that perspective. It is important to note that the development of AI tools, at least at this point in our lives, we've recognized that it must be done in recognition and guaranteeing of fundamental rights of individuals, including the right to privacy. And for me, because this focus is actually on data protection, which is just one of the many aspects, that fundamental rights touches on, I would want to say that, I will not, in order to be able to do justice within the time, I will not touch on the other rights, which we very well know that AI's tools will have implications on. Now, when we look at the data protection laws currently across Africa, I would like to say that majority of these laws have been developed to further guarantee the rights of individuals to the privacy of their communications. Usually, this fundamental right to privacy is enshrined in almost all the African countries that have data protection laws, constitutions, except for South Africa, whose data protection law extends the protection of personal data to company data. Most of the laws tie, the rights to privacy and the right to data protection to tie it to individuals or living persons, if I should put it that way. What that therefore means for my purposes is that we need to, I'm solely looking at the processing of data sets that belong to individuals and have impact on their rights as guaranteed under data protection laws that we find. To the extent that these data protection laws define general principles which must be adhered to in order to protect individuals or persons, we have come to realize that AIs more or less poses significant challenges to how some of these principles must be respected within the context of AI algorithms that are being developed. Particularly, most of our data protection laws that we see across the continent, you're likely to find maybe 6 principles, 7 principles, or 8 principles. Most of these principles are looking at the ensuring that in the processing of individual or personal data, information that is processed is done fairly in recognition of the individual's right to privacy. Most of the principles also recognize the fact that when individuals' information is being processed, they must be told or they must be informed of why their information is being processed, to what extent it is going to be used. It is also required under these principles that anybody that is processing such information is transparent and open in the manner in which they are collecting and using or handling the information of individuals. The principles also require that you put in, anybody that is processing an individual data puts in adequate security safeguards, both technical and logical, and organizational safeguards in order to ensure that the individual's information that is being used or processed is appropriately protected. There is also requirements around making sure that such individuals are involved and part of the process. Usually this is found under principles that we call data subject participation, which says that you need to inform the data subject of how their information is being collected, how it is being processed, or how it is being handled. And then there are also requirements around the quality of the information. So making sure that the information that is being collected or processed is up to date, is accurate, up to date, and useful for the purpose for which it is being collected. So these principles, as you see, are general principles, and there's a reason that these are done under data protection laws. First of all, it is important to note that especially the pace at which, the law seems to chase technologies. Most of these laws have been developed to be more technologically neutral. And so ideally, what that means is that if you're a regulator in this space, you will be put under a lot of pressure, especially when you're looking at these generic laws, to define application, to provide further guidelines on how these principles work. And as Bev had mentioned earlier, if you look across Africa, most of our laws have these principles. The challenge, however, is that, and probably it is also because AI is still fairly new on the continent, we haven't seen comprehensive guidelines coming from our regulators, as you see from their counterparts in Europe and other parts of the world. Now, the challenges posed by AI to data protection essentially stems from the following areas: the manner in which information is usually collected and processed within AI systems or structures. Usually, you know, because of the manner in which information has to be collected, and the fact that you normally have different data sets being collected from different sources because of the enormity of the data sets that is required, both to train AI data sets and to ensure that AI tools are working in the way in which they're supposed to work. There's all kinds of information that is being collected. Some of this information also involves personal data. Now, the challenge there is that whereas data protection laws are requiring you to specify the purpose for which you're collecting the information, and if there is a further processing, you should make sure that it is compatible with the first purpose for which you're collecting that information, then you have a significant challenge. And that challenge for an AI developer is to be able to demonstrate that, first of all, an individual has either directly or indirectly consented to the processing of their information. Assuming that you are collecting these data sets from third parties, from people that you are not necessarily dealing directly with, assuming that you are scraping from the internet. And I believe Clearview AI, the recent finds of Clearview AI may come to mind. You know, assuming that you are scraping, to what extent are you then able to demonstrate or inform individuals or ensure that the individuals, one, are informed about how their information is processed, or who is collecting images of them on the internet, or who is doing what with their information? And that is an extremely challenging area that we need to look at. Another has to do with being able to be open, right? So if individual, typically, if I am on a particular platform or my images are available virtually and somebody is scraping my image, to how are they able to get back to me to let me know that, oh, Teki, at this point in time, I collected a picture of yours and I'm going to use it for this purpose. So if you're not comfortable with it, let me know so I can, you know, address it appropriately. So the issue of transparency and making the data subjects aware of what information has been collected and is also being used in AI processing, AI tools, is also a challenge. Then you come to the issue of minimization. And the concept of minimization says that collect for only the purpose that you're using it for. And the challenge comes in where where AI developers are collecting information from third parties, which goes beyond, and the purpose for which their information is being collected goes beyond what they're going to use it for which reason, at the point where maybe my information, the first point where my information is collected or given, it has been taken with a specific mandate in mind to process for a specific purpose. And on that basis, I only provided what is needed. Now with AI tools, particularly you're looking at maybe tools in the medical field, tools in assessing eligibility of people to particular products or services and other things, then this kind of information is being, how would I put it, to that information is collected from one source, then another from a hospital, and another from other third-party organizations. The question is, what exactly are these AI companies collecting, right? And to what purpose? Also, because of the extent to which AIs are being trained and their potential to be used for other things beyond what we know, there's that temptation to collect as much information as you can have, right? We are talking even earlier about the potential of surveillance and other things that are coming with it. So there are a lot of risks to data protection and protection of individuals' right to privacy under these principles if we look at the AI principles as a whole. But interestingly, globally on the whole, we all agree that AI technologies have something that they are going to offer. And even though the complexities of these AI algorithms in explaining how decisions are being made by these tools, in explaining to individuals for them to understand how information is being handled, in helping with articulation of the impacts of these AI tools, there are still risks. And the best way of addressing these risks must come from both what I'll call the private sector organizations that are developing these AI tools, and more importantly, also from our regulators in the space. Because even with the basic principles that we have, it is important to define which areas will be appropriate and which areas are no-go areas, for instance, for AI. Now, the issue is, how do we then balance, right? For instance, issues around purpose specification, use limitation with AI's ability to discover new and unforeseen purposes. Is this something that we want to do? Is this something that we want to limit only to the training of AI tools? Or is this something that we want to expand? Also, for data protection regulators that are prevalent across Africa, there is that question of, the possibility of AI regulation going outside the scope of data protection. As colleagues from earlier had looked at, there are ethical issues and considerations that needs to be made beyond the rights to privacy. There are other fundamental rights, such as the right to expression, such as the rights to economic well-being and right to education, and so many other rights that are equally impacted by these AI tools. And so our regulators need to, sometimes there's that challenge, because invariably when you are a regulator in this space, you'll be expected to handle all those things. So to what extent as a continent are we going to look at these issues beyond the context of the data protection laws, which only limit application of the laws and its scope to individuals whose information are being collected and processed by these platforms? And I think that going forward, it's still early days yet, but there's a lot that the regulators can do. One, they need to start coming out looking critically at these principle-based issues on a sector-by-sector basis. And by sector basis, what I'm saying is that if there is an AI tool that is processing information for the health sector, I think that the risks are different, looking at each of the issues that will come up from there, and they must be looked at and addressed appropriately. If we're looking at it from the perspective of security and intelligence and other things, the risks posed is different. And so it is important to ensure that, we're coming up with guidelines to further guide the development of these tools. And we shouldn't shy away from, where there is an extremely high risk that will affect the lives of people, that will affect the freedoms of individuals, that will impact significantly negatively on the fundamental rights of individuals, we shouldn't shy away from saying no to the processing of these tools within the AI framework. I think I will end it here.
Thank you so much. I invite our other panelists to turn their videos on as well, because we now like to move into the discussion part of our event today. And I strongly ask everyone in the audience to submit their questions as well in the chat, or raise your hand if you have a question. I'll start with something while we're waiting for some questions here that I think I was thinking of throughout all the presentations, and especially I think when Arthur was talking about the way it should be for responsible AI, it seemed to me that overall this was a very strongly a matter of stakeholder awareness, education on what AI is and isn't and where it's working, as well as stakeholder consultation. I wondered, first of all, Arthur, your thoughts on that is kind of a central point to how things should be, as well as for Tiki and Bev, where we're maybe already seeing that, or where you think aspects of this kind of education, awareness, stakeholder consultation are being used or should be used.
Shall I start?
Sure.
Yeah, I think it's because of, I think, the definition of artificial intelligence, because, you know, there's no agreed definition. Some think that it's a technology. So if you go to an average computer science class today, they actually think artificial intelligence is part of software development. So this is what is causing some problems. Whereas artificial intelligence is a big phenomenon. It's changing the way we are going to live our world in this world. It's not even about machine learning. Machine learning is much narrower. So I think if we take artificial intelligence as maybe at a micro or meso level as socio-technical systems that comprise, you know, the technology, the human beings, the morals, the values, the motives, then I think we are beginning to talk, and who is going to benefit? So that's what artificial intelligence is about, which is empowering, that locates, you know, the technology within the socio-technical systems. But let's move a little bit further up, which is, you know, the macro system, where we are talking about how artificial intelligence is going to change international relations, diplomacy, how we relate as human beings. So there again, you know, the issue of the human and the social comes into the equation about who are the stakeholders. So it's not just about government, which is why China, sometimes for the bad stuff it does, is doing it well, because it actually says it's a all of society approach to artificial intelligence, which means every person in society, not just a computer scientist, should be involved in the design of artificial intelligence. And then Saestra, one of the professors in Europe, talks about the social. Let's bring in the human and the social back into AI, or it has never been into AI. So that's where it is important. And then also consulting the people who are going to be impacted in order for us to avoid epistemic injustices. Yeah, thank you.
Go ahead, Bev.
I can add something here. I think there is a need really to, in a socio-technical system, because they exist in an environment with humans and they interact with humans, and certainly a lot of the robots that we work with at the University of York, what we're trying to also have a look at is how we can really embed within the system some kind of high-level principles or some kind of norms, or some such even social, cultural, ethical, and empathetic norms within the system itself. And this involves, of course, bridging the gap between these high-level principles and the actual operational rules, But there are processes in place where you can really reduce these high-level normative principles into operational rules and be able to really embed within the system some type, not to create a moral machine in any sense of the word at all, but really to make them more somewhat social, ethical, empathetic, and culturally aware or sensitive in the way in which they execute their functionality. And in doing so, of course, you would need to look at stakeholders, and you need to look at cohorts or groups of people who have vested interests or otherwise, the users, lay people, ethicists, lawyers, the developers, and try and embedding those rules and in creating those rules, somehow get the input of the stakeholders to really understand what those rules should look like. So I think stakeholder engagement is very important. And then on the other side, of course, the stakeholder engagement around really informing public policy. And I think there's a big movement around deliberative public engagement and the way in which the general public and various interested parties and otherwise can also inform the process and the way in which the law more generally and regulation is written. So I think stakeholders, of course, have a very important role in this process.
Yeah, Caitlin, I definitely there's the need for a lot of education and particularly from the continent and even beyond data protection. And that is because even if you isolate an area like data protection, already on the continent, we have expert challenges, right? We have very few experts on the continent that really understand these laws. Then within even that challenge of data protection experts understanding the law, you have a challenge of understanding AI and AI technological systems. And it is in order to make this work, I agree with Bev, it is important to bring all these ecosystems together. We have to be the lawyers that have the data protection expertise, the data protection practitioners, the policy makers, the lawmakers. They need to be in the same room as the developers, as the educators, as even the sociological and the likes of the philosophers, that we all need to be in the same room to really demystify what these issues are. And I think that is one of the starting points to that. So even if we're saying that regulators should develop guidelines, one of the effective ways of coming up with some of these guidelines and tools is to bring all these stakeholders together in the development of the guidelines. And it's important to identify them and to get them involved now, especially for a continent where we are now beginning to address the issues. Unfortunately, we're not seeing a lot of that happening. I have just recently begun talking to some AI communities developing data sets about potential training and awareness around data protection, around ethics, around the risks, that are coming up from there. And it's important because when you have these communications with the people that are developing the tools, which will be used, invariably, a lot of them have heard very little or usually have very little to do with principles like data protection, let alone if you go further into other human rights and ethical considerations.
Thank you all. Yeah, I think I definitely agree with those sentiments. That picked up on something else I think about educating and working with designers. It came up in multiple discussions here, this idea of, I think Arthur said, datafication. We were talking about data minimization and I had kind of two questions on this. One was more about location-wise, how might this idea of datafication and these asymmetric systems that are being built up impact the global South in a particular way? What might be unique about how that's going to impact the global South? And also a little related to what Tiki was just saying, who is responsible for this data minimization? Does it have to be built into the design? We saw that with a lot of, for instance, the Corona apps and contact tracing apps, you know, that they were built decentralized so that they weren't actually gathering any data. But at the same time, we're talking about the fact that we need data and we need more appropriate data. So is it about managing data correctly, or is it about designing in a way that we're not gathering as much data? So there's kind of a geographical question there and a kind of which stakeholder needs to be responsible question there for anyone to start.
Okay, maybe I'll start. When it comes to data minimization, remember it's closely really linked to the purpose for which you're collecting information. And I think a lot of people make this mistake of don't collect data at all. And you know, that really defeats the purpose of data protection laws. If you look closely at the principles around data minimization, specification of purpose, and other reasons for that. So really, each context, right, is going to define what we're going to do. And I like the fact that you brought in the COVID example. We had countries that were collecting everything that they can collect. And we recognize the risks to that collection around surveillance and other reasons, which was not the basis for the collection. And we were able to, regulators came up and said, no, you should be able to collect this within the context. And even within that, we were able to collect just what we needed to use it for the purpose for which we're collecting. In places like Ghana, we saw the impact of what we call call data records, right? The impact of CDRs, first in dealing with the Ebola outbreak, and then subsequently in dealing with the COVID pandemic and so on. Now, the interesting thing with how some of these principles or how some of these technologies were implemented is that even though it was collecting call data records, which had other aspects of data that made it, you know, very risky to process, right? These tools were used in a way that stripped the data of the highly sensitive and risky forms of data to ensure that, yes, if you want to look at migration and movement of data, which is very critical to managing the risks that were coming up as a result of the pandemic, then it was easier to say that, okay, give the core data records, but strip it off, you know, the sensitive personal information that will increase the risks. On the contrary, if you're going to give money to somebody that requires the money, then there are other forms of information that you want to give, right? Which is also required, and to what extent. So all these things can be done. But I think that the challenge is that we really need to look at it from a specific purpose or use perspective, you know, so that we can then define for each context how the information, we cannot use the generic principles to define generic, again, guidelines for all sets of data that is used in the AI systems. So we really have to go down to what use am I looking at here? What data is going to be involved in this use? And then you can then craft these principles to address that.
I think just to add to that, and I concur with all of the previous speakers really, but maybe to really just consider the whole AI ecosystem, or the whole design process and the whole life cycle of the AI product from the very beginning all the way through, as well as the data ecosystem and how that will then work within the whole framework. And then also to maybe be quite cognizant of the fact that there are it's like a multi-layered approach to the governance and regulation of an AI type system. So in other words, you may have legislation and regulation which serves a particular purpose, and you may need to obviously be more compliant with that. But then there are also ethical instruments and their guidelines, and there's protocols and standards. and various other technological measures. So you might have privacy by design or by default, or even ethics by in and through design, and then value sensitive design type technologies, which can all inform the way in which you really, as a whole, holistic sort of structure, really make the AI system far more regulatory friendly and compliant in all aspects of it. But I think when you're looking at AI, I think we kind of use it in a very generic term, but I think they're very specific applications. And I think each application and each life cycle of a particular application needs to be dealt with very specifically. And I think you need to look at that multi-layered approach of all governance tools that you may have at your disposal to really inform the whole process. So, I mean, that would be my takeaway as far as that's concerned.
Great, thanks. Arthur, any thoughts on the datafication and data minimization in Africa?
I think I agree with both speakers. I think let me just maybe address the geopolitical angle. When you're looking at the power asymmetries, I think what's happening in Europe right now, European Union changed, the tone to digital sovereignty, about 2 years ago. The European Union never used to talk about sovereignty, but it's actually seeing how the United States, China, and different parts of the world are creating domination capacities, because countries are going towards strategic autonomy, but also domination. So I think data protection is not just a matter of law, but a lot of things. The technology that is actually needed to be invested into data protection is enormous. Let's talk, for example, the European Gaia X at the moment. This is taken a lot of investment in order for them to protect industrial, non-personal data. So I think part of the reason why Africa finds it easy just to outsource such services either to China or to German companies, where some of the data, like Senegalese data, was stored in Europe, is because the technology, the technical know-how that is needed in order to protect the data is quite sophisticated. But it's not enough, I think, for the Senegalese government to simply say, well, we are taking away our government data from Europe and we are going to hand it over to China. And then they claim sovereignty to say, now we are sovereign. They are not. It's actually creating further power asymmetries, because China is where it is today in terms of technology sophistication, not just because of machine learning algorithms and all that, but because of data. Because artificial intelligence is about data, machine learning is about huge, data sets. So collection of data, information, that is not data today. Tomorrow is going to be like gold. So the data that is being collected today is going to enrich a politician, is going to enrich a power broker, a data analytics company. So we need to ask the why, the purpose for which, the data is being collected. But more so, I think for my continent, Africa, some of that data is only waiting for one day where it is going to be shared. We are going to be persecuted. You are going to be excluded. You are going to be extorted because of the data about you that is being collected. So we need to be careful. I think Africa needs to invest not only in technological artifacts, but also in norms. We need norms and concepts on why we are collecting data. So norms are very, very important. There is a reason why France is calling for data sovereignty. There's a reason why China and Russia have got data sovereignty norms. So Africa, I think what we lack is what I call collective political agency and norms that underpin our approaches to data management. Thank you.
Thank you all so much. I'm going to move over to our friend Gasu Kamara, who raised his hand. Gasu, if you could unmute yourself, that'd be great.
Yes, thank you very much, Caitlin, for allowing me to ask my question. Thank you also for organizing this workshop with this very interesting topic. So my question is about the user perspective of AI and data protection. What I mean by user perspective is that it's a kind of comparison between, sometimes when we collect the data, we ask some permission to the user or to the person to give permission to collect the data and give permission to use this data for processing some application. But sometimes the user of this AI application has a need. So sometimes, how do we leverage the need of the application of the AI tool and the permission the application is asking to the user? I can give another example. For example, by opening a Gmail account or a Facebook account, or when you download a software from the internet, you have always be asking to accept the license or to approve some things. So if I need a Gmail account, and behind there are many conditions on how Google will use my data. So do I refuse and then do not have the Gmail account, or do I accept to have my Gmail account and then give some rights to Google to process my data? And another example is that you are using, for example, an email account for 10 years, and then the company changes the rules or the terms and then ask you to accept the new terms. So you have been using this for 10 years, and then now do you refuse and then lose all your data or your contacts, or do you accept knowing that maybe some of these terms are not suitable for you? So this is why I wanted to ask this question about the user perspective on how to leverage the need of using the AI app and the permission you have to give to this app to process your data. This is the first step. And the second step is, for me, the user can accept to use the application with giving some permission to the app, but behind we are talking about regulation. Can we have a second layer of control from the government level or from the institutional level, who is I don't know, controlling how these data are processed by the application? So I don't know if I am clear in my question or my, yeah. So this is what I wanted to say. I have a lot of questions, a lot of things, but we have so less time, so I will skip on this question.
Thank you so much, Asu. I've had this conversation with others as well about kind of the luxury of being able to care about data collection, right? There's some things we just have to use in our daily lives, or for path dependency reasons we're locked into it. And if anyone wants to comment on Gus's question, go ahead.
I can start.
Oh, okay.
Yeah, I think, well, I was teaching digital ethics course to the graduate school last year, and that question, I think, has been arising within the context of the European Union, the GDPR, that the consent provision within the GDPR useless, because we are given consent rights by the right hand. But sometimes I think because of the power of the big tech is we simply consent because we've got no choice. You know, they can give you the procedures or right to redress, to say, if you're not happy, this is what you do. But who is going to find the time to write to Google if I need an email account today to apply for my visa to go to the UK? Do I have the time to think about it, to negotiate with Google, to say, well, I don't really agree with your terms and conditions? So this is a field of ethics or micro ethics on how big tech actually create power asymmetries between them and the individual users. So a number of scholars have looked into that question to say, I think maybe in respect of certain aspects of the GDPR, maybe instead of having individual consent, there should be group consent. There are different philosophical and ethical approaches that have been suggested, but there isn't really one clear answer. But at a second level, which is I think beyond ethics, is a question of technology, the technology owning countries or regions like Shenzhen and Silicon Valley, because they've got the power. So that's why we are here today, complaining about Facebook, about Google and all that, because they've got the power. They dictate their terms and conditions to people in Ghana, to people in Rwanda, people all over the world. So it's a problem. It's actually a big problem that is being discussed within the ethics community, and how the GDPR is actually flawed in terms of its consent position. So my quick answer to you, I think you are stuck. We are all stuck. You cannot say, I'm not going to open a Google account because of these conditions. What if you need it? What if your university needs that account? So that's the reason why you are seeing a number of people are fleeing Twitter, going to a new app called Mastodon or something, yeah. Or people end up leaving WhatsApp and then going to Signal. People end up saying, I'm closing my Facebook account. Or people say, well, instead of using Gmail, I'm going to use a locally hosted. But those are very small steps that actually do not address the systemic challenges, which have got something to do with institutional and systemic power that this big tech wield and possess. Thank you.
Any thoughts, Tiki or Beth? Yeah, go ahead.
Yeah, I just wanted to say that I think this is where the role of law plays a significant part. And then by the role of law, I would say that the regulators are extremely important in ensuring that we have a level playing field. Unfortunately for us on the continent, we haven't seen, particularly when it comes to data protection, we haven't seen that strong and robust regulatory framework that is able to hold accountable these, call them large corporations, right, that more or less have power, and then we have limited power. But again, that is why laws like, I disagree to some extent with Arthur, that is why laws like the GDPR also changed the scenery to some extent in terms of how personal data is handled within Europe. And we like to call it a golden standard, but what it in fact did was that and we see it now just this week, we've seen the Irish data protection regulator fine I believe Meta for certain violations. We've seen in the last few years, we've seen the ICO's interventions around Clearview. We have seen, so having the best way to resolve these things are to make sure that we have rules, and we make sure that everybody at all plays by the rules. The challenge we have as a continent is that because most of these tools are developed outside of our continent, usually our regulators do not have that power. And that is where I agree with Arthur that we need to find other ways of addressing the power asymmetry. And from my perspective, I think that, that's why pushing for harmonization of our laws, pushing for a stronger, more together regulatory presence, particularly around data protection, will be a good step, right? So that because together as a continent, we have a stronger voice than we do as individuals across, and we may be able to do a lot more. But yeah, I think that some of these can be resolved to some extent by having the right legislative framework, having an effective regulator, and from the continent's perspective, coming together to ensure that, you know, we speak with one voice.
Thank you. Bev, you have any thoughts on that?
I think just to discuss a little bit the idea of consent, and really that, of course, it's stipulated within a particular data protection framework, whatever it may be. Normally it would be informed or specific and voluntarily given. And I think the question really speaks to that, and that is, can it be voluntarily given if in fact you actually are denied some kind of privilege or some kind of access to something if you don't give it? So what extent is it really informed consent? Because you can't really, I mean, you may not have a full understanding of exactly what you're in fact consenting to, or what the downstream implications of your consent may be. So I think to some extent, perhaps consent is a bit of an empty concept, or empty construct, I should say, and it's very contextual in its, in its narrative. So there are, of course, issues with consent. So I would agree with the question as far as that is concerned, but how particularly to address it, I mean, that is again up for debate and is not easily resolved.
Thank you all. We have a time hopefully for 2 more questions that I have. One comes from our audience, and that is related maybe a little bit to what Arthur was saying about the fear of data being misused or used against you or something like that. Is Africa prepared for an impactful data security breach, and relatively compared to how it's being handled in other parts of the world as well? Any quick thoughts on that?
Is Africa?
Yeah.
Can you repeat the question?
I'm sorry. Is Africa prepared for an impactful large-scale data breach of some sort relative to maybe how regulations and systems are set up around the world and other places?
No, I don't think so. I think when you look at maybe the Sony and scandal about 5 years ago, the breaches that we have seen in the world, our cybersecurity, I think our preparedness as a continent is very weak. And why is it weak? Because I think our cybersecurity is actually led mostly by the fintech. We have got a private interest, so they not only antivirus and all this. So these are private applications. So banks are protecting themselves, but the digital goods or the public infrastructure is actually not really protected. So if we were to have cyber attacks at the level of Sony attacks that happened about 5 years ago, we are not prepared as a continent, because Europe has got collective agency. What I mean by collective agency is that they come together and they draft their laws and they deploy technologies together to defend the European values, the European cloud. But in Africa, we don't do that. I think look at a country like Zimbabwe. 5 years ago, we had what was called Baba Juko, who was a troll on Facebook, who gave serious problems to the government. And the government was saying we are under cyber attack because of one troll on Facebook. So we are not prepared as a continent, because we are not acting together with one voice. But let us not even be afraid of a cyber attack, because our own governments are actually giving away our information for a pittance. To China today, we've got facial recognition technologies, we've got foreigners owning our data. So why are we even afraid of foreigners attacking us when in fact we are voluntarily surrendering our data, our own sovereignty, and our own future in the interest of your political interests? Thank you.
Tiki, have anything to add to that, or should I move on to her last question?
I think that it's a very difficult question for me to answer, and so I was going to refrain from that. And that stems from the fact that when you say, are we ready to protect an attack on the continent, what do we really mean? Because we have to, again, something like that needs to be properly contextualized, right? Are we looking at public infrastructure? And even if you're looking at public infrastructure, we need to ask ourselves, how much of Africa's public infrastructure sits within our continent or countries, right? Then if you're looking at private sector, you also have to ask yourself similar thing. And then you come to the context of the laws that we have in the countries, how do they even regulate the cybersecurity space, right? What do the laws say about critical infrastructure? How is it supposed to be governed and all of that? And what are the practical measures also as countries, as a continent, that are being undertaken to protect us? And I think that when you dig deep, you realize that it's a very complex state where we cannot just, so yes, you will find that we get attacks, our industries also get attacks in the space, but it's very varied. And in certain situations, yes, we have the capability to address some of those. In some situations, we don't. But I think that it has to really be looked at contextually to identify what particular risk are you looking at? What kind of ecosystem are we looking at? And then we can define whether or not, as a whole on the continent, we are protected. But from where I sit, I wouldn't say that just because we're Africa, we are at a higher risk than other jurisdictions.
Do you have a thought, Bev? Or
yeah, I do have a thought. I'm not by any means a cybersecurity expert at all, so I think I need to defer to Arthur perhaps in this regard. But just to say one thing, and that is when you talk about Africa, perhaps we do have a low level of maturity in terms of cybersecurity attacks, but each jurisdiction within Africa needs to be considered very separately to some extent. And I know, for example, South Africa does have a Cybersecurity Act that has quite recently been promulgated, but it may not be true of other countries within Africa. So maybe on the whole, we can make a statement such as it has a low level of maturity, and perhaps it does. But I also think that within each jurisdiction within the African continent, I think things may be at different levels and being dealt with in different ways. So I think it's just to really caution the framing of the whole African as a whole, rather than as individual countries with sovereign,
Yeah, and I had a comment in the chat as well to think about international frameworks and make sure they're ready and responsive, and governments are ready to put in these international frameworks as well.
Let me chip in for 1 minute. I think I was talking because I once worked with the Cybersecurity Center at UCT, and we were doing maturity training for African countries with Oxford University. And for the few months I worked at the Cybersecurity Center, that was my conclusion, that we are not prepared. Sometimes, countries, governments do not even know what critical infrastructure is. They don't even have any plan in place. So it wasn't simply an emotional response by someone who's in Europe. It was because I worked on these issues at the University of Cape Town. And only, I think, one country, maybe South Africa, had some sort of plan on cybersecurity. Most countries, they are actually beginning to put plans in place about protection of the critical infrastructure. But Ghana was quite advanced because Ghana was working with the World Bank, is it? And yeah, I think we can talk about that with Turkey later.
Yeah, I think that some of these things, I agree, we need to properly contextualize it, right? Because even if you're looking at cybersecurity profiles, I can even say that there are organizations that are existent in Africa that have their parent bodies in Europe. And so even with them, you may rate them higher, right, than you would rate maybe smaller African companies. So that's why I'm saying that we really need to situate it within the right context to be able to answer. And even if you're talking about I mean, you have worked on it, but there are various factors that go into readiness and ability for a country to be able to do its work, to say that a country is cybersecurity ready, you know. So there are various factors, and it will not be fair to lump the entire continent together and then rate us as a whole. Even speaking from that, there's a lot going on within the AU framework, within Smart Africa, and even the Malabo Convention was particularly a significant work that was pushed. It was mainly for the cybersecurity angle. And I think that as a continent, that understanding is actually there, right? That the cybersecurity risks are there and we need to approach it. Of course, in terms of readiness, I don't think that we can compare to maybe other parts of the world, but there's some work that is happening.
Thank you all. I think the fact that I only got through a fraction of my questions and we are out of time speaks to how much there is to talk about on this topic. So I really appreciate the three of you taking the time, and our audience for also taking the time and listening in. I hope we can continue these conversations. In the chat, you saw how you can connect with RAIN Africa. So that's a great place for us all to start and to continue these conversations. And please share, audience, guests, panelists, everyone, keep sharing your work on this so that we can all keep learning from each other. So with that, I say goodbye to you all and thank our panelists once again. And I hope you all have a great rest of the day. Thank you, guys.